Case Law Number 03/2016 AL. On the case of divorce. Including 4 parts. Part 1. Source of the case law. Part 2. Overview of the case law. Part 3. Content of the case. Part 4. Assessment of the court. Part 5. Rules. This case law was adopted by the Judicial Council of the Supreme People's Court on April 6, 2016. And promulgated by the Chief Justice of the Supreme People's Court under Decision Number 220 QDCA dated April 6, 2016. Part 1. Source of the case law. Cassation Decision Number 208/2013 DSGDT dated May 3, 2013 on divorce case of the Civil Court of the Supreme People's Court in Hanoi between the defendant, Mr. Pham Gia Nam. Husband, the plaintiff, Ms. Du Thi Hong. Wife. The persons with related rights and obligations were Mr. Pham Gia Phac, Ms. Phang Thi Thai, Mr. Pham Gia An, Ms. Pham Thi Lu, Mr. Bui Van Dap, and Ms. Du Thi Nak Ha. Part 2. Overview of the case law. Case law situation. In the case where parents grant the land use right of a certain land area to their child and his or her spouse, the couple has built a permanent house on that land area for their residence. When the couple was building, their parents and other family members did not have any objections. The couple even used the house and land continuously, publicly, and stably, have implemented procedures to declare their land use rights, and have been granted the certificate of land use rights. Legal resolution. The court shall determine that the land use rights are gifted to the couple. Keywords of the case law. Divorce. Common property of husband and wife. Gift of property. Basis for establishing ownership rights. Establishing ownership rights pursuant to agreement. Part 3. Content of the case. Ms. Du Thi Hong and Mr. Pham Gia Nam married in 1992. And registered their marriage at the People's Committee of Van Thao Commune, Tien Tin District, Hanoi. After living together for a period of time, these arose conflict between the couple, causing them to live separately since September 2008. On April 18, 2009, Ms. Hong initiated a lawsuit to request a divorce from Mr. Nam. And Mr. Nam consented. With regard to their children, the couple had 2 children who were Pham Gia Kong, born in 1992, and Pham Hong Yang, born in 2000. Both Ms. Hong and Mr. Nam wanted to raise the 2 children alone, and did not request any support from the other. Kong wished to live with his father Mr. Nam while Yang wanted to live with her mother Ms. Hong. With regard to the property, during their time living together, the couple built a 2-story house in 2002. Additionally, an attic to relieve the heat was built in 2005. The house was built on a land lot of 80 square meters in Van Hoa Village, Van Thao Commune, Tien Tin District. The couple agreed that the house was their common property. They failed to agree with respect to the land. According to Ms. Hong, the land belonged to the family of Mr. Pham Gia Phac, Mr. Nam's natural father, whom was granted in 1992 for resettlement. Later, Mr. Phac and his family met and announced that they were gifting to the couple the land, but no documents were made. In 2001, Mr. Phac instructed and Mr. Nam implemented procedures for the Red Book. Thus, was granted the certificate of land use rights under Mr. Pham Gia Nam's name as the representative of the household. Therefore, such land use rights are the common property of the couple. Ms. Hong requested that she be entitled to continue using the house and the land. And, in return, she was willing to pay half of the value of the land use rights and assets attached to the land to Mr. Nam in accordance with the price determined by the Valuation Council. According to Mr. Nam, this land lot was granted to his parents in 1992. His parents only allowed the couple to temporarily live there and did not gift them the land use rights because his family had many children. In 2001, he declared and implemented procedures for land documents by himself without his family's knowledge. His opinion is that the land is to be returned to Mr. Phak. According to Mr. Phak and Ms. Tai, Nam's parents, Mr. Phak was originally granted the land by the People's Committee of Antau Commune in 1992. Mr. Phak built a level 4 house on that land. In 1993, his family allowed Mr. Nam and Ms. Hong to live in that house but did not to gift the land to the couple because Ms. Tai had been paralyzed for 15 years now. Mr. Phak and Mr. An, Mr. Nam's younger brother, was caring for her, and Mr. Phak's family wished to leave the land to Mr. An because Mr. An did not have his own house. When Mr. Phak's family was granted the land, there were only 4 members in the family, consisting of Mr. Phak, Ms. Tai, Ms. Liu, and Mr. An. Mr. Nam had already moved away. Only when Ms. Hong requested for divorce, Mr. Phak's family became aware that Mr. Nam had obtained the land documents under his name in 2001. Thus, Mr. Phak and Ms. Tai requested Mr. Nam and Ms. Hong return the land to them. Besides, during the settlement process of the case, Ms. Hong further stated that Mr. Nam had been granted by the Army officer, University, number 1 of the land lot with area of 125 square meters in Thatchdat district. At first, she requested to divide this land lot, but later she withdrew that request. In terms of loans, according to Ms. Hong, she and her husband received a loan from Ms. Hong Ti-Chu, Ms. Hong's mother, of 0.75 tael of gold 9,999. A loan from Mr. Bui Van Dap of VND 150 million with an interest rate of 1.25% per month. A loan from Ms. Du Tinakha, Ms. Hong's older sister, of 1 tael of gold 9,999. All of these loans were made without any written agreement. Ms. Hong requested Mr. Nam to repay those loans together with her. According to Mr. Nam, the couple only owed a loan to Ms. Chu of 0.75 tael of gold, for which he had repaid her an amount of VND 13,875,000, equivalent to 0.375 tael of gold. He is not aware of any other loans, and he does not agree to repay them as requested by Ms. Hong. On November 3, 2010, the Valuation Council valued the property as follows. Land use rights: 80 square meters x VND 22 million per square meter equals VND 1,760,000,000. House: VND 475,865,000. The total value of the property is VND 2,235,865,000. In first instance judgment number 03/2011 HNGDST dated May 17, 2011, the People's Court of Tianjin District, Hanoi finds that, in terms of husband and wife relationship, Ms. Du Tihong was entitled to divorce Mr. Pham Gia Nam. In terms of their children, assigning Pham Hong Yang, born on August 14, 2000, to Ms. Hong to raise until adulthood. Temporarily suspending the child support obligations of Mr. Nam until Ms. Hong requests child support. Mr. Nam has the right to visit their children, which no one can prevent. Common property and contributions. Confirming that the two-story house with one attic and all other construction works on land lot number 63, Cadastral map number 5 in Van Hoa Village, Van Thao Commune, Tieng Tin District, Hanoi were recognized as the common property of Ms. Du Thi Hong and Mr. Pham Gia Nam. Such common property had the value of VND 475,865,000. Confirming that the land use rights of 80 square meters of the land lot number 63. Cadastral map number 5 in Van Hoa Village, Van Thao Commune, Tieng Tin District, Hanoi were recognized belonging to Mr. Pham Gia Phac's household. Compelling Ms. Du Thi Hong and Mr. Pham Gia Nam to return to Mr. Phac's household the land use rights of 80 square meters of land lot number 63. Cadastral map number 5 in Van Hoa Village, Van Thao Commune, Tieng Tin District, Hanoi. Assigning Mr. Pham Gia Phac's household the ownership rights of all assets on that land lot including the two-story house and all other constructions works on the land. Compelling Mr. Pham Gia Phac to pay both Ms. Du Thi Hong and Mr. Pham Gia Nam, each of them an amount of VND 237,932,500. Recommending that the People's Committee of Tieng Tin District to revoke Certificate of Land Use Rights No. U 60645 issued on December 21, 2001 under the name of Mr. Pham Gia Nam in order to implement procedures to grant to Mr. Pham Gia Phac when Mr. Phac requests. Recognizing Mr. Pham Gia Nam's voluntary support to Ms. Du Thi Hong of an amount of VND 800,000.000. Compelling Ms. Du Thi Hong to pay Mr. Bui Van Dap an amount of VND 179,820,000. Rejecting all other requests of Ms. Du Thi Hong. In addition, the first instance court ruled on court fees and the right to appeal. On May 19, 2011, Ms. Hong submitted an appeal against the entire first instance judgment. On May 24, 2011, Mr. Nam submitted an appeal disagreeing with the support for Ms. Hong of an amount of VND 800 million to find a new home. However, at the appellate hearing, Mr. Nam withdrew his request for appeal. In Appellate Judgment Number 105-2011 LHPT dated August 30, 2011 and September 6, 2011, the People's Court of Hanoi ruled to uphold First Instance Marriage and Family Judgment Number 03-2011 HNGDST dated May 17, 2011 of the People's Court of Tieng Tin District, Hanoi, as mentioned above. In addition, the appellate court ruled on the court fees. After the appellate hearing, Ms. Hong and Ms. Long Ti Chu submitted a petition to propose cassation procedures for the aforementioned appellate judgment. In Protest Decision Number 05-2013 NOTS HNGDLD dated January 3, 2013, the Chief Justice of the Supreme People's Court protested against Appellate Marriage and Family Judgment Number 105-2011 LHPT dated August 30, 2011, and September 6, 2011 of People's Court of Hanoi, proposing that the Civil Court of the Supreme People's Court to conduct cassation procedures in the direction set aside the appellate marriage and family judgment mentioned above, and First Instance Marriage and Family Judgment Number 03-2011 HNGDST dated May 17, 2011 of the People's Court of Tieng Tin District, Hanoi regarding properties. Transferring the case to the People's Court of Tieng Tin District, Hanoi, to reconduct the first instance procedures in accordance with the law. In the cassation hearing, the representative of the Supreme People's Procuracy opined that, with respect to the dispute, when the resettlement land was granted to Mr. Phac's family, Mr. Nam was not there. Since there was no evidence that Mr. Nam's parents gifted the land use rights to Mr. Nam and his wife, the land still belonged to Mr. Phac's family. The determination by the two levels of courts that the land belonged to the parents of Mr. Nam has basis There was a mistake in the loan from Miss Chu. Therefore, it is recommended that the Council of Adjudicators do not accept the protest of the Chief Justice of the Supreme People's Court. Part 4. Assessment of the Court. The Cassation Council of the Civil Court of the Supreme People's Court finds, in terms of the marriage relationship and children, the lower courts had already resolved. The parties had no further complaints. In terms of property, the property disputed by the parties is a land area of 80 square meters in Van Hoa Village, Van Thao Commune, Tiên Tin District, Hanoi, under the name of Mr. Pham Gia Nam. The documents demonstrated that Mr. Phak was originally granted the land by the People's Committee of Van Thao Commune in 1992. Pursuant to the minutes on the handover of the land from the People's Committee of the Commune to Mr. Phak, Ms. Hong had already married Mr. Nam by the time that the minutes was made. However, as verified by the First Instance Court of Van Thao Commune in Tiên Tin District on the procedures for granting land, Van Thao Commune had a policy of granting land for resettlement since 1991. Even though at the time when the procedures for granting land, Mr. Phak's family had only 4 members living together including Mr. Phak, Ms. Tai, Ms. Liu, Mr. An, Mr. Nam was in the army and had not returned. The grant of land for resettlement was granted to households with many members. Granted to Mr. Phak, his wife, and children. Therefore, Mr. Nam was also among the subjects to be granted the land. After receiving the land, Mr. Phak and his wife built a level 4 house. In 1993, Mr. Phak's family allowed Mr. Nam and Ms. Hong to live on that land area. And they were the persons who managed and used the land continuously since then. Ms. Hong opined that Mr. Phak's family had announced that they were gifting the couple the land area mentioned above. But Mr. Nam and Mr. Phak asserted that the family did not gift it to the couple. Considering, as verified by the People's Committee of Van Thao Commune, in 2001, the commune organized the households in the commune to register for issuance of certificates of land use rights, and the households made declarations at the headquarters of the commune, BL 103. All households in the commune were aware of the policy for the land declaration. Mr. Phak was the owner of the land, but he did not go make the declaration. Mr. Nam, who was at that time living on that land and also the person who went to declare and implement procedures of issuance of the certificate. On December 21, 2001, Mr. Nam was granted Certificate of Land Use Rights No. U 60645 under his name being Pham Gia Nam. The couple had already built the 2-story permanent house in 2002 and in 2005. They built an additional attic as floor 3. Mr. Phak and other family members were aware of the construction by Mr. Nam and Ms. Hong. But no one objected. Thus, from when the certificate was granted, in 2001, until the time Mr. Nam and Ms. Hong divorced, in 2009, Mr. Phak's family did not complain regarding the land grant and house construction. This fact demonstrates the intention of Mr. Phak's family to gift the land area mentioned above to Mr. Nam and Ms. Hong. Therefore, Mr. Phak's and Mr. Nam's testimonies that Mr. Nam declared the land documents without Mr. Phak's knowledge has no basis for acceptance. There is a basis to determine that Ms. Hong's testimony that Mr. Phak's family gifted the land area mentioned above to the couple has basis. Therefore, the rulings of the lower courts that Mr. Phak had no knowledge of Mr. Nam's implementation of procedures, the land documents, that Ms. Hong's testimony on her husband's family gifting the property had no basis in order to determine that the land area of 80 square meters in Van Hoa Village, Van Thao Commune, Tiên Tin District, Hanoi was the property of Mr. Pham Gia Phak's household. And concurrently, Mr. Nam and Ms. Hong were compelled to return the land to Mr. Phak's family were incorrect. The above-mentioned land under dispute should have been determined as the common property of Mr. Nam and Ms. Hong. When dividing it, Mr. Nam's greater contributions should have been considered in order to divide based on each party's contributions. The division for the parties should be based on each party's need for residence to guarantee the rights and interests of the involved parties. In terms of the complaints of Ms. Hong T-Chu, Ms. Hong's natural mother, whereas, on May 7, 2011, before the first instance hearing, Ms. Chu submitted a petition to the People's Court of Tianjin District with the content as follows: Today is May 7, 2011, I have received an amount repaid Ms. Hong and Mr. Nam. I no longer request the court to resolve this. The first instance court declared that Ms. Chu's advance court fee of VND 200,000 was to be submitted to the Treasury but did not declare the suspension of the settlement of Ms. Chu's request concerning the loan, which were not in accordance with the regulations specified under Article 192.1 d of the Civil Procedure Code. However, after the first instance hearing, Ms. Chu did not submit an appeal and the Procuracy did not submit a protest. Therefore, based on Article 263 of the Civil Procedure Code, the Appellate Hearing Council only reviewed the parts of the first instance judgments, which are appealed, protested against, or related to the review of the appealed or protested contents, and the protest of the Chief Justice of the Supreme People's Court against the aforesaid content was unnecessary. Therefore, the Cassation Council of the Civil Court of the Supreme People's Court finds that the protest by the Chief Justice of the Supreme People's Court about the property in dispute, particularly a land lot of 80 square meters in Van Hoa Village, Van Thao Commune, Tianjin District, Hanoi, had basis for acceptance. Part 5. Rules. In light of the aforesaid reasons, pursuant to Article 291.2, Article 297.3 and Article 299 of the Civil Procedure Code, to set aside Appellate Marriage and Family Judgment No. 105-2011 LHPT dated August 30, 2011 and September 6, 2011 of the People's Court of Hanoi and First Instance Marriage and Family Judgment No. 3 2011 HNGDST dated May 17, 2011 of Tianjin People's Court in Hanoi in respect of the parts concerning the property relations. The divorce case between the plaintiff Ms. Du Tihong and the defendant Mr. Pham Jianam has been settled. To transfer the case to People's Court of Tianjin District, Hanoi for conducting first instance procedures in accordance with the law.